What happens if someone, tunes into you or goes to your blog, follows your advice and has bad consequences? Well, you need to do things to protect yourself against that because look, you're providing some information, but you're not in a one-on-one relationship with these people. You don't know the facts of their situation. You can't control what they do.
Get ready to build, protect, and sell your expertise online with the Online Genius Podcast. You'll laugh. We hope you won't cry, but you'll always be informed and prepared so you can have the success you want. Here's your host, Bobby Klinck.
Hey there. Welcome to this week's episode of the Online Genius Podcast. I'm your host, Bobby Klinck, and I am really excited for today's episode because we are continuing our legal mini training series. And today we're talking about a topic that there's just absolutely no question that you as an online entrepreneur need to understand. And what we're going to talk about is the legal requirements and what you need to do to keep your website safe and make sure that your website and all of your online presence doesn't become a drag on your business. And so that's a pretty important topic for you as an online entrepreneur because look, your website, your online presence, that is your business. And so we need to make sure that what you're doing related to your website and your online presence is all good. It's all a blessing and not a curse. Now, that's what we're going to talk about today. We're going to really get into the specifics of what you need to be doing on an ongoing basis to protect your business, to make sure that you're doing things right. So with that, let's go ahead and dive in. Now, the first thing I want to talk about is a general notion and get you to understand a general concept, which is that because you're doing business online, there are additional requirements and considerations that don't apply to people who aren't building an online business. Now, honestly, today, most everybody has an online presence, even a brick and mortar business. But if a business just has a pretty simple, plain, here's where we are, here's the products we have, and doesn't really do anything else, isn't trying to collect leads or trying to do anything else with their online presence, there's not a lot they have to do to stay compliant. But because you're actually doing a lot of things to build your business, to build your platform online, there are special rules. Now, there are some laws that apply. For example, you've probably heard of CAN-SPAM, which is a federal law here in the United States that applies to email marketing. And so there are rules that apply to that. And it has to do with certain things you have to give people and some information you have to provide to them. But then there are other laws. Another one you've probably heard about is the GDPR, which is a European Union law that has to do with the processing of private information. And it includes anything you're doing when you're collecting information online. So building your email list, etc. And so that has some implications here. But then there are some laws you probably haven't really heard of. There's one called CalAPA, which is the California Online Privacy Protection Act. It's been on the books since about 2002 or 2003. And what it does is it says, hey, if you're collecting information from California residents, you have to provide certain information to them. And so it's basically requiring you to provide information to people who come to your website if they're from California. Then there's a law called COPPA, the Children's Online Privacy Protection Act. This is a federal law. And it says that, hey, you can't collect private information or personal information about anyone under the age of 13 without the express permission of their parents. And so that's another layer of complexity that comes into things. So you can kind of see that there's a lot of different legal issues that come into your website. And that's in addition to the just kind of general rules that we all have to comply with in business. So there's a lot of these added complexities and added things that you need to think about. But aside from the legal issues, strictly of laws that apply, there is the bigger problem that when you're using your website or a web presence to build a platform, you're kind of doing something different. And what I mean by that is you're not primarily dealing with people one-on-one. Now, when they come to pay you and to hire you, maybe that's how it works. But you probably have a blog or a podcast or a video show or something where you're providing information in a one-to-many format. And what that means, a couple things. Number one, it means that a lot more people are going to be exposed to your message, to the information you're putting out there. But it also means that by nature, you're acting as a teacher. You are providing people with information, and hopefully they're going to listen to you and go and try to take some of your advice or some of the information you're providing and to actually apply it to their business. And that leads to a separate problem for you, which is what happens if someone, tunes into you or goes to your blog, follows your advice and has bad consequences? Well, you need to do things to protect yourself against that because look, you're providing some information, but you're not in a one-on-one relationship with these people. You don't know the facts of their situation. You can't control what they do. And so that kind of also leads to an extra layer of caution you need to take with your online presence. Now, the key to dealing both with the legal requirements, but also this added risk is to have solid policies in place on your website. Now, I'm not going to dive into email marketing and what you need to be doing to be compliant in this episode. I may do an episode on that later. I haven't decided, but there's a lot of information out there about how do you comply with canned spam? How do you comply with these other rules? Now, what we're going to talk about are the basic requirements, the 3 core policies that you need to have on your website. And those policies are a terms of use, a privacy policy, and a disclaimer. Now, when I say policies, what these are, each one of those policies, you're going to have a separate page on your website for each one, a terms of use page, a privacy policy page, and a disclaimer page. And you're going to set out these policies, these just kind of written agreements, written things that you're going to have down on your site. Then you're going to have links to it in the footer of your page, probably not anywhere else, but you've seen it in lots of web pages where they have the legal stuff. And so you'll have links where people can view those things. So that's what we're talking about today. And I'm going to walk you through the role that each one of these policies plays, and then what you need to include and what you need to be putting in there. So let's dive into the first of these policies, the terms of use. Now, a terms of use is, at a broad level, it is the rules of the road for your website. It's where you set out the basic agreement between you and your website visitors. So you're going to set out, hey, what are the general things that are allowed? What are the things that generally aren't allowed? You're going to set out some basic requirements and, some basic kind of background rules for your business. And the idea is simply to say, hey, look, here's the overall agreement between you, visitor, and me, the website owner. And so it's going to set the ground rules. Now, with that, what you're going to find is that there's a lot of boilerplate or, just kind of standard legal language that you're going to include or want to include in your terms of use, because this is, like I said, a very basic rules of the road. So let's talk through some of the boilerplate you're going to include first before we get to the specifics. Now, the first thing you're going to do is you're going to have a clause that incorporates those other 2 agreements that we talked about, or the other 2 policies, the privacy policy and the disclaimer, and says, hey, this terms of use together with the privacy policy and the disclaimer are the agreement between you and me, website visitor. Now, the reason you're going to do that is that when you sell something through your website, you're going to want to have someone click a button to say they accept your terms of use. And when they do that, they're not just accepting your terms of use and agreeing to it, they're also going to be agreeing to your privacy policy and your disclaimer. And you don't have to get them to click multiple times. You don't have to put multiple links. You just say you're agreeing to my terms of use, and the terms of use incorporates those other agreements. Now, then some of the other things that you're going to say that are just pretty standard language that you're going to see in everyone. One, you're going to say that you have the right to change the terms of use, that you have the right to make changes, and that it's the obligation of the person who visits the website to check it from time to time. You're going to say that you have the right to withdraw the website. Again, you shouldn't have to say that, but you should put it in there anyway. In other words, you can turn the website off anytime. And this is important if some people have come to rely and believe that they're entitled to the information you provide, et cetera. So you would just want to put that in. You're going to limit the use of your website to lawful purposes. So you're going to say, hey, you can't use my website for anything that is illegal. Now, I don't know what that would be in your case, but it might be depending on what you do. So you just want to say, hey, you're not going to take the information we give you and use it for an illegal purpose. The next boilerplate clause you're going to have in there is you're going to reserve your rights in what's called the intellectual property on your website. In other words, saying, hey, all the content here, we own it. We're not giving it to you. We're not transferring it. We're not giving up any rights. You have the right to look at it, and that's it. And the same thing with your brand. You're going to say, hey, my trademarks, my logo, my slogan, those are all protected as well, and you don't have a right to use that just because you see it on the website. Again, from a strict legal perspective, you don't have to say that. There's no requirement that you reserve your rights to intellectual property. You own them. But it's a good practice to do because it will at least put people on notice that, okay, I don't have the right to just take this stuff. He's saying I do it. So that's the purpose of that. Now, another thing you're going to have, and this may stun you, is you're going to say that there are no guarantees as to the accuracy of the information on this website. And the reason why you're going to do that is you may have some typos. The things may change. You may have, a blog post about Facebook advertising, for example, if that's what you do, and it may change. And so that advice may no longer be accurate. And you don't want to have to, be sure and be on the hook for going and changing that on an ongoing basis and being absolutely sure there's no inaccuracies on your website. But also, look, the reality is there's going to be typos. There's going to be things like that. So you just want to have that on your website as well. So there is no question. Now, there's again going to be more boilerplate. So let's keep going here. You're going to tell them or, get them to agree that email and electronic communication, that, hey, if they send you an email or electronic communication, they are consenting to you to respond, but that they're also consenting that you're going to keep it, et cetera, that you're going to keep it consistent with whatever your general policies are. Now, you're also, if you have any kind of communication services or interactive elements on your website, so chat boxes, comment boxes, things where people are interacting with each other, you definitely need to have a section on that says, that they have to act appropriately, they have to act legally, they have to act respectfully, they can't be abusive in using those services. So kind of, boilerplate, hey, be nice and don't do anything illegal on this website. Now, the next thing you're going to want to put is a clause that gives you the right to use anything they submit to you. In other words, if they submit a comment on a blog post, you want it to be very clear that by doing that, they are consenting to allow you to use that. You've probably heard me in this podcast at some point or in one of the prior episodes talk about the right to publicity. You just want to make very clear, hey, if you submit something, you can't complain that I use it because I am going to use this commercially. Another boilerplate clause you're going to include is a statement that links to third-party websites and services. You don't control what's there. You definitely can't control the accuracy of stuff on other websites. But you're going to say, look, we're providing this because we think it's valuable. But you're not going to guarantee it, and you're going to just make clear that you don't control it. Now, another thing, and we'll talk about this a little more in the disclaimer section, but you're going to include something here in the terms of use too, probably, that says, hey, I'm not making any warranties. My liability is very limited here. So this is the kind of thing that says, hey, you can't sue me for something on this website because I'm not warranting anything about it. And a warranty is, you probably thought about it in the context of a car or a new product. Essentially, a warranty is, hey, this product or service is good for the purpose that it was made, and it will be good for a certain period of time. You're just saying, hey, there's no warranties with this website. There's nothing. There's no guarantees of any kind. Now, you're also going to have, most likely, or you should have, a clause that addresses how any disputes will be resolved. Now, this could be a couple of different things. You might just say that, hey, if you have a dispute, you have to come to wherever you are. So in my case, Washington, D.C., and you can only file a lawsuit in a court in Washington, D.C., in my case, but you would pick wherever you are. In other words, you're saying, hey, if you want to sue me about anything, even though you can't sue me, you're saying before, but even if you think you can sue me for something on this website, you have to come to my home court to bring that case. So that's part of what you're going to do. But you might do something different, which is to say, we're not even going to go to court at all. We're going to use what's called an arbitrator, a private decision maker who has the authority to decide any disputes. Now, this is actually what most lawyers would suggest to you. And the reason why is this. although you have to pay an arbitrator. So there's that added expense. An arbitration will generally be resolved more quickly than a court. And so what you pay to the arbitrator, you're going to save on paying to a lawyer down the line. But also there are advantages in the context of a website or any one-to-many application, which is that with an arbitration clause, if you say, hey, that's how we're going to resolve things through arbitration, you can say, and it can only be one-on-one. You have to bring an arbitration against me individually. You can't join together with other people who visited my site and have a similar complaint. You've got to come against me individually. And there are advantages to that. So I'll just tell you, I use an arbitration clause in my agreements personally because I think it's the better way to go. So those kind of at a broad level are the boilerplate. And I know I went through them quickly, but the fact is that it's hard to do them justice. It's hard to spend a ton of time on each one unless you wanted this episode to be about 3 hours long. But the important thing is those clauses are all going to be standard issue in just about every template you find anywhere. You could go to the free templates and they should have all of that stuff already in there. The important point is the stuff we're going to talk about now. And this is the specifics. These are the things that would be more specific to your business. Some of them are more specific because you're an online entrepreneur and they will be common to most online entrepreneurs. And then some of them are things that you might have to tweak, and you're going to have to tweak based on your personal policies. So the first kind of specific provision you're going to need to have is a clause that addresses what they can do with templates or forms that they download from your site if they buy something from you. So in my case, I have, products for sale. And so again, let me back up here. When you have a course, and you'll remember this from the written agreements episode that we did last week, if you have a course or any membership or something like that, you're going to have a standalone agreement for that. But what you're not going to have most likely are standalone agreements for $40 products that you sell, $47 products, even $97 products, because you don't really need separate agreements for each of those. So what you're going to do is in the terms of use of your website, you're going to have these standard policies. So in my case, I sell template legal forms that people can buy. So with those, one of the restrictions I have is, hey, you buy these from me, you can use them for your individual or business use, but you cannot resell them. And you cannot offer them to your clients. You can't do anything like that because they have to buy them separately. And so those are the kinds of restrictions you're going to want to put into your terms of use. Similarly, I can think of examples of people I know who have printable designs that people can then use for things, to create design elements. Well, that's the kind of thing you're going to want to say, hey, if you download that template, you get to use it individually. There's a company out there that I purchased from that sells Canva templates that you can use to create things like your Facebook cover page, for example. And again, they would be wise to have in their terms of use that, hey, when I sell this to you, I'm selling you the right to use it individually for yourself or your one business. So you get that. This is kind of like the limits you would see in a software license that says, hey, this is for a single use, not for multiple uses. So you're going to have that kind of limitation on your templates and forms and any other paid products or materials that are not things that you're going to have a separate agreement for. So you need to think this through. Most likely in your business, you will have a single policy that applies to everything other than your courses and your materials. If you don't, you're going to need to consider maybe having a terms and conditions for that separate product. So, but generally that's not going to be an issue because generally you're going to have kind of a single policy that applies. Now, another thing though that you need to use or to include is a restriction on what people can do with the free downloadable content. Now, again, when you give them this, people often will be under the misconception that they are getting all rights to copy it, to distribute it, etc. And they're not. Just as a general matter, even if you didn't say anything else, they wouldn't have that right. But you want to make very specific in your terms of use that, hey, when you download this guide, this is for you to use. You don't distribute it. You don't send it out to people. You don't copy it and give it to others. No, this is for your use. Again, the point of this is they get something free, that's great. And if they want other people to have it, they should send those other people to your download page. They shouldn't be just giving them the downloadable content. So those are kind of in one class of things you need to consider. It's for your paid products, but also for your free products. What are the limits on what people can do with that content that you're giving them? And again, those are things that it's kind of specific to the fact that we're online entrepreneurs, so we're doing this. But then it's also, you have to think through what is your limitations, what are your policies, and make sure to include those. The next thing you need to think about is if you have guests on your platform. So for example, if you have a podcast, if you have guest bloggers, if you have any of that stuff, you're going to want to put something in, a couple things. I mean, in my terms of use, an important part is I say, look, I can't guarantee the accuracy of anything they say. If you listen to this podcast for long, I'm interviewing experts who they have expertise well beyond what I know in the particular area. And so I can't possibly vet them. That's not my job. My job is to provide the information and to allow my listeners to judge for themselves. I obviously try my best to vet them. I'm not going and getting people that I think don't know what they're talking about, but my terms of use makes very clear that, hey, I'm not responsible for verifying the accuracy of what they say. So you don't rely upon me for it being accurate. So that's the point of a guest disclaimer in your terms of use. Then there's a couple of other policies we need to talk about. You need a cancellation policy and a refund policy if either of those applies to you. So a cancellation policy, if you have any ongoing monthly memberships or anything like that, you are required by law to have an explanation somewhere of how they can cancel. And so that's going to go in your terms of use. So again, it should be very simple that, hey, if you want to cancel, you can do that. Again, my view, most times when you're going to have a cancellation policy, it's going to be for something that you should have a separate written agreement for, a separate terms and conditions for. That being said, I think you should include it in your general terms of use because people may not be able to find that terms and conditions for that product later. So it's just good to have it so they know how to cancel if they want to cancel their membership or whatever it is that they have an ongoing payment for. So that's a cancellation policy. You have to set that out. You should not make them jump through hoops. It should be simple, set up an email address or whatever you want to do, but make it very simple and easy for them to be able to cancel. Then the next is you need to lay out whether you have a money-back guarantee or a refund policy, and if so, what it is. So, with digital products, I would call it a money-back guarantee versus a refund would be for something else. Even if your policy is there are no refunds, you need to lay that out. Say there are no refunds. Or if you have a refund policy, you need to set out, yes, we have a refund policy. Here are the requirements and make it specific so there's no question. Getting back to last week where we talked about written agreements, you'll remember a big part of the agreement is to make sure there is no disagreement down the road. So with your refund policy, you want it to be clear and really black and white so that it's either a yes or a no. There's no gray area about whether they complied with the policy. So it could be a simple thing like my policy is it's a 30-day money-back guarantee, period. There's no requirements. If you email me within 30 days, you get a refund. Other people have a show your work. But if that's what you have, you need to set out what do they need to show you exactly, what are they going to need to submit so that there's just no issue. So in broad terms, those are kind of the specifics you're going to need in your terms of use. Now, if you have certain things about your business that are different, there may be some other things, but those are the big points you're going to need. Now, that is, in a broad nutshell, in whatever we've been talking about, 15 minutes, what you have in terms of use. That's a big policy. It's important, and it's the general rules of the road. The next policy you need, the second policy that you have to have, is your privacy policy. And this one is not optional. Under CalAPA, that California Online Privacy Protection Act, and the GDPR, the General Data Protection Regulation from the EU, both of those require you to disclose certain information to people when you're collecting information from them. That means you have to have a privacy policy. It's just that simple. That's the only way that you can reasonably meet that requirement. But it's also good practice. I mean, people are going to want to see it, and I'm going to tell you that certain advertising places, I don't know if Facebook does, but certain places where you might have ads running will require that you have a privacy policy linked to on whatever landing page where you're sending people from that ad. And so again, it's just not optional. You're going to have it. Now, what does a privacy policy do? Broadly speaking, it's going to give an explanation of what information you're collecting, why you're collecting it, and what you're doing with it. That's kind of in a broad nutshell, but I'm going to walk through it a bit more specifically. But the idea here is to really give people an understanding of what it is that you're collecting and some other basic information so they understand what's happening to their data and to their information. That's the goal of these privacy policies. Now, the first piece of a privacy policy is you're going to have to provide some identification and contact information. Now, it's not clear, I'm going to tell you exactly how detailed this has to be, but you have to definitely provide some contact information. The best practice is to provide an email address and a physical address where they could send a letter to you if they have a complaint. Again, I suspect maybe that at some point this physical address will go away at some point, but it hasn't yet. Most people are still including it. I include it. Under the GDPR, I'll tell you, it says that you have to provide, I don't remember the exact language, but it says contact information. It doesn't specifically say what that is, but the guidance that most people are giving is it includes an address. And so there's a few different people that you need to provide information to. The most basic is the company behind the website. So you, in my case, Your Online Genius, LLC, or for my law firm, Klinck, LLC. So you have to identify that, provide contact information. So I'm providing an email address and a physical address where they could send a package or send a letter or whatever. The notion is if someone wants to get in contact with you, they should be able to. Then there are a couple of other things under the GDPR specific. I'm not going to get into these in specifics. You'll have to, kind of go back and check out the GDPR issues. This may or may not apply to you. If you have a GDPR representative, and you'll know if you do or you don't, you have to identify them and provide their contact information in your privacy policy. And similarly, this one almost certainly doesn't apply to you, but if you have a data protection officer, so if you're a company that's in the business basically processing private information, you have to have a data protection officer. You probably don't need that. You would have to identify that person as well. So that's kind of the identify and provide contact information. In your case, it's most likely going to be your company, and then maybe, depending on the determination you make, a GDPR representative. But for most people, your company is going to be the important piece there. Now, the next part of your privacy policy is you have to tell visitors what information you're collecting from them. And some of this is pretty obvious, right? I mean, you're collecting their name, their email address, and this other information that they submit to you. So you'll want to tell them, hey, if you submit information to us in response to an opt-in form, a sales page, a survey, any of that, we're collecting that information. But you also have to tell them about the information that you collect automatically. And when I say automatically, that is, you need to tell them that you're using Google Analytics. You need to tell them that you have a Facebook pixel. You need to tell them that you use some cookies on your website to just track some things. All of this behind the scenes stuff you need to disclose. Now, the detail to which you have to disclose it is, you don't have to go into grand detail. Now, what I'll tell you is if you are in the EU or your website is specifically targeting the EU, there's a separate requirement called the cookie directive that requires a little bit more. But for the typical entrepreneur, what you have to do is provide a little bit of information. And again, it'll say, we collect the information you provide to us. We also use Google Analytics and other tracking to track how you process through our website, where you look, etc. We use the Facebook pixel, we use cookies. And you're generally going to say that data is generally, not associated with them in any personal way unless and until they provide their personal information. And you're going to tell them that, but you have to tell them that you're doing that. Again, it's kind of a dirty little secret. Most of the people here listening to this show probably know, well, of course everybody does that. But if you talk to the regular person on the street, they don't understand the Facebook pixel. They don't even know it exists. They may not even know about Google Analytics. And so that's why you have to disclose that. So beyond telling them what you collect, though, you have to tell them why you're collecting it. What is the purpose of collecting the information? Now, some of it is simply to perform the agreement between you and me so that I can provide you. And you don't have to go into great detail, but you have to say, hey, so that I can provide you with the service that you've asked for. And that would include giving them freebies or selling them a product. But it's for other things as well. You might say, some of it is to improve the functioning of our website. That's why you're using Google Analytics. It's to do that. It's to target marketing offers and promotions to them. It's to do all of those different things. Whatever you're using this information for, you need to disclose. Then you need to tell them what you will do with the information. So again, this is kind of related to the why you collect it because, for example, you're going to tell them that we will, among other things, give you targeted promotions based upon the information you provide. And you could tell them some other things like that. And that language is going to cover, for example, if you do Facebook advertising or if you do some tagging within your email service provider based upon their activity and send offers to some but not others. So again, you're going to have all of that information disclosed. Again, you don't have to disclose exactly what you're doing, but say that you're tailoring offers and promotions based on their behavior. But you're also going to tell them, hey, like I said, we are going to have to share this information with other people. And so that's the next step that's important. Now, some people have gone overboard and are literally trying to list every single person they share information with. That, in my view, is a mistake. The law doesn't require you to do that. It says either the recipients or categories of recipients. That's the GDPR standard. But this, you might say, well, I don't share with anybody, but you do. You have an email service provider that has the data most likely. You are sharing it with outside vendors who help you with these processes, who help you with actually delivering stuff. So you need to explain who those are in broad categories. Again, you can say it's vendors, it's affiliates, it's et cetera. Whoever it is that you might be sharing this information with, you need to disclose. Now, if you are in the EU, there are some other requirements, like you're going to have to tell them if you intend to remove the data from the EU. So if you're over in Europe and you're using a vendor who is outside of Europe, which you probably are if you have one of these email service providers, because I think, a good number of them are outside the EU, you need to tell your visitors that you will be removing the data from the EU. That's just a special requirement that's required under the GDPR for folks in the EU. Now, another thing you need to tell people is generally how long you're going to keep the data. And you may not know exactly, but you might say that we're going to keep the data you provide until it's no longer useful or until you ask us to delete it. Maybe that's what you do. But you have to include those kinds of categories so they have some sense of how long you're going to keep this data. Then there is this special requirement under the GDPR, this General Data Protection Regulation. There are certain rights that people have under the GDPR that you are required to inform them of. Think of it like the Miranda warning, but we have to give it to consumers as the company, and we have to tell them these things. It's just required. So this is kind of boilerplate you're going to include. So you have to tell them that they have the right to access, to correction, and to erasure. So in other words, they have the right to know what information you have on them, to correct anything that they have wrong, or to ask that it be deleted or erased. Again, it's unlikely people are going to ask for a correction in your case, but you have to tell them that. You have to tell them that they have the right to withdraw consent for you to continue to hold or process the data. So if you have their data because they consented, you have to tell them they have the right to withdraw that. You have to tell them they have a right to lodge a complaint with a regulatory authority over in Europe. You have to tell them that, if the information is used and could have statutory or contractual, could affect things like that, it probably won't in your case. You have to disclose that. You probably don't have to worry about that one. And then there's a requirement that if you're doing automated decision making, and this, let me be clear, the automated decision making here is things like using a credit check to determine whether you'll do business with people, or using a credit check to determine the rates that people will be quoted. Something like that, where there is they give you data, automated process will then, make a decision that affects a statutory or contractual right of theirs. You have to tell them that. So you have to inform them of that, how the decision is made, et cetera. For most online entrepreneurs, that doesn't apply. This is not about kind of automations within your system or your email service provider. It's more complex things where you are really making these determinations about whether you'll do business with them or on what terms you'll do business with them based upon automated decision, not you making it manually, but an automated system making those determinations. This is a notion that has to do with people having a right to have a human take a look. So that's it. That's the GDPR requirements in a broad nutshell. And that actually brings us to the end of the privacy policy section. So again, you're going to tell them who you are, where they can find you, what information you collect, why you collect it, what you're going to do with it, who you're going to share it with, how long you're going to keep it, and then these GDPR rights. Largely, that's what you have to have in your privacy policy these days. So that's the second policy. Now we're going to turn to the third policy. And this is the one that candidly is missed the most. This is the disclaimer. And the disclaimer serves a few different roles. But what I'm going to tell you is you should love your disclaimer. Your disclaimer is all about protecting you. So it's about preventing you from being sued, from being chased by regulators, and generally from having disputes. So you should use them. Now, there's a few different pieces that you're going to include. I like to break it up into kind of 4 different sections that we're going to talk about. One is a section explaining it's education, not advice. The second section is disclosing your financial incentives. The third section is the results are not typical section. And then the fourth is the boilerplate clauses. So we're going to talk about those in turn. So let's start with that first one. And this relates back to that big kind of extra burden that I talked about at the beginning. Because you're doing this one-to-many providing information on your website, you need to inform your visitors that you're providing education and information, not advice. Your website is not professional advice. So let me give you an example. On my law firm website, Klinck LLC, I provide nothing but legal services to my clients of that website. That's Klinck LLC. That's what I do. But I make very clear that my website is not legal advice. My website is education and information. So I'm going to stress that point because even if in your actual one-on-one relationships, you are giving professional advice of some sort, maybe it's legal advice or tax advice or financial advice or health advice or anything like that, you don't give advice on your website. I just want to get you to get that in your head. On your website, on your blog, on your podcast, on social media, you are not giving advice. You are giving education and information. The difference between the two is that advice, at least in my case, in my view, I need to know your particular facts and circumstances. I can't give you advice without knowing a lot of details. That's why there's this classical joke that lawyers will always say, it depends. Well, it's true. In the law, it does depend, but it's also true often in the case of, health or wellness or medical or that stuff. It depends. What are your particular situations? So that's the distinction you're drawing. You say, hey, on my website, I'm not giving you advice. I'm giving you general education and information. So no matter what you do, you should use at least a generic clause that says I'm providing education and information, not professional advice on this website. But if you're in a specific area, so if you talk about things related to law, for example, or finance, or tax, or health, or medical, or wellness, you should provide a specific thing that says, let's just use financial advice. So you're saying, I'm not providing financial advice. I'm providing financial education and information. And this website is not a substitute for advice from a finance professional. So it's a bit more than that, but that's the gist of what these clauses are saying. So that's what you're going to do, but include at least a generic one. But if you provide specific kinds of information on an area where there are people might think you're giving professional advice, use a more specific one. So that's the first important piece. That's the education, not advice clause. And it's really more than that, more than one clause, but you're going to have that. So the next area that you're going to put in your disclaimer are disclosures about your financial incentives on your website. Now, the Federal Trade Commission here in the United States has a general rule, and the general rule is basically, it's kind of truth in advertising, truth in marketing, that people have a right to know what your reasons might be. So here's where it comes in. If you are getting discounts for products that you review, you got to disclose that. People are entitled to know that you're getting a product at a discount when you give a review. Obviously, if you were being paid to review it, you have to be told specifically you're being paid to review it. But I don't know a lot of people who are actually being paid to give reviews. But you may have heard about this in context of the FTC going after some influencers because they were tweeting and not disclosing that it was an ad. They weren't disclosing that they were being paid to promote a product. And the FTC said, no, that's not fair. You have to tell people that you're promoting this, that you're getting paid. The other place other than the reviews that it comes in is affiliate links. So if you're doing affiliate links, you're going to need to disclose that so that people understand that, hey, if they click on that link and then they buy something, that you will get a financial reward. Now, you can't just do this stuff in your disclaimers, by the way. You're going to have to be a little bit more prominent. So if you do a review on a product that you got, for free, you're going to need to disclose it there. But you could say, hey, we got this, for free. You can find more information in our disclaimer and link to here if you wanted to. Same thing with affiliate links. You could say, hey, these are affiliate links. You can learn more in our disclaimer. Or you say, hey, these are affiliate links. We might get something, if you buy. Now, one other area that probably won't apply, but might. If you have ownership in another company that you are promoting on your website. So let's say that I had a business, in my case, that I have Klinck LLC, right? And if I were promoting from Klinck LLC, Your Online Genius, and not telling people that, hey, Your Online Genius, I own that company too, you could see how people might want to know that, right? They might want to know, hey, this guy is saying that this Your Online Genius is the best thing since, sliced bread, I should take his advice. Well, they should know that I own it. Now, in that case, it's obviously pretty silly example because everybody would know that I own Your Online Genius. But you can think of examples where you're like a behind the scenes partner or have a financial interest in some other company. You should generally just disclose it. And so that way people know that, you're going to get some potential upside if they buy it just by the other company making money. So that's your financial incentive. So you got to disclose all that stuff in your disclaimer. The next area is results are not typical. And that's not good enough. You can't just say that. What you should do is generally say that, look, the testimonials and any earnings claims that I've had on here, they are accurate. They are what these people actually gave me and told me is true, but they are not necessarily typical. You'll say that results will vary and depend on the circumstances that are outside of your control, including the efforts and the particular circumstances of the individuals, and that you are not making any guarantees that people will have the same results because you can't guarantee that. Obviously, you can't. If you have, a case study of someone who's knocked it out of the park, they probably knocked it out of the park because they were exceptional, because they did an exceptional amount of work, because they applied it perfectly, because they had some particular insights, et cetera. So you have to just make clear to people that you're not guaranteeing they're going to get the same results, because otherwise people might believe that. It's also just generally a requirement. So when you're using testimonials or earnings claims like, oh, hey, this person used my process and made, $20,000 in the first month, you definitely have to tell them those results are not typical. So that's kind of the results are not typical section. And after that, we get to the boilerplate. And the boilerplate, this is largely the you can't sue me stuff. And so you're going to have, we talked about this briefly during the terms of use, you're going to have a section that says you are making no warranties. This is going to be a big, ugly beast of a clause because it's going to have a lot of commas in a row where you're saying I'm not making any warranties, including, and you're going to list a bunch of different warranties that you're not making. And, it's going to be ugly. It's going to be written in legalese, but it serves a purpose. It's basically saying I'm not promising you anything about my product or service or my website or anything else. So don't expect it. Then you're going to have a similarly long, ugly clause of a limitation of liability. So this is going to say that, hey, even though, I'm providing this, I cannot be sued to the maximum extent allowed by law. And even if I were, you can't collect, and you're going to have a long list of different kinds of damages that they can't collect from you. So again, these clauses may or may not be effective, but you need to have them because you want them there to be effective to the maximum extent allowed. And so you're going to include those to protect yourself, to avoid getting sued in the first place. Then you're going to have an errors and omissions clause generally that says, hey, there may be errors, there may be mistakes on this website. You got to forgive me. I'm not representing that this is accurate. We kind of talked about this in the terms of use as well. And then you're going to have personal responsibility clauses, a clause that essentially says, look, it's your personal responsibility for your actions. You, visitor, are the one who are responsible for making sure, checking the accuracy of this, figuring out whether the information I provide you applies to you, whether it will work in your circumstance, all of that stuff. You're saying, look, it's not on me, it's on you. This goes back to I'm providing you with information. So you're just making it very crystal clear that ultimately they are responsible. You're not. So that's what you need to do. You're going to need to put that in the boilerplate. And that is kind of the end of your disclaimer. Now, again, if you look at a typical disclaimer, it's going to be probably 5-6 pages long, printed out in a Microsoft Word document. So there's a lot of stuff in there, but it generally falls into those 4 big sections we talked about. So that's it. Remember what we've talked about. You have to have 3 policies: your terms of use, your privacy policy, and your disclaimer. Now, we've covered a lot here. I have a free guide that walks through this if you want a printable guide that you can get by going to youronlinegenius.com/website guide. It walks through these policies again, and just so you have something written that you can take with you. Again, youronlinegenius.com/website guide, and you can get a little more information, or at least take kind of a written document with you so that you can have this information. So if you get those 3 policies in place, you will be leaps and bounds of progress versus if you don't. But you can't just sit here and not do it. This is just something, it's a must because you're an online entrepreneur. You've got to have this stuff in place. So go ahead, get these in place, and you will have your website protected from a legal perspective. That's it for this week. Again, this is Bobby Klinck. I'll be back next week with another. We're going to get into some specifics next week. We're going to be talking about some interesting stuff that really applies to you. So I look forward to it. Until then, this is Bobby Klinck. I will talk to you later.
Thanks for listening, and remember to visit mistakes.youronlinegenius.com to get your essential guide to the 4 legal mistakes that can doom your business and how to avoid them. Join us next week for another episode to expand your online genius and your success.